Hello, everybody. Thank you for joining us for this webinar, our webinar on data transfers post-SHREM, the practical considerations of transferring data. With me today is Omer Tene, Vice President and Chief Knowledge Officer from the IPP. And our agenda today is starting with a very quick overview of the events, the recent events, including some very recent developments, and then really answering the question, so what now? What are our next steps? How do we assess our transfers? What are these supplementary measures, and what are legal safeguards that we can take to address this issue? And we'll try to leave ample time for questions and answers. We know that this is a topic that brings up many good considerations, and we will definitely want to be able to provide you with the chance to ask questions. So, with no further ado, let's jump into the program. Omer?
Thanks a lot, Sagi. It's a pleasure to be here. Thank you for inviting me, and I'd like to thank all our listeners for joining. So I don't want to bury the lead, so I'll say that there was a very major development in this respect just yesterday, and I'll get to it at the end. But sort of rewinding a month and a half back, it was summer, so people might have forgotten. They were distracted by the sun, vacations, hopefully. The Schrems II decision of the Court of Justice of the EU came down on July 16th, much awaited decision. The case formerly called Facebook versus Ireland Data Protection Commissioner. And as I'm sure people on this call know, the court decided a couple of things. First of all, that the Privacy Shield framework is invalid. So for more than 5,000 companies that use Privacy Shield to transfer data from Europe to the US, they had to immediately pivot to a new solution. The court also decided that standard contractual clauses, which are used by far more than 5,000 companies, we don't know the exact number, but we're probably talking about tens or even hundreds of thousands of companies, those standard clauses are still valid. But, and this is a big but, the court cast a cloud over the validity of using the standard clauses in certain circumstances, and specifically in that case involving Facebook and transfers to the United States. And I'm going to read just a paragraph out of the decision because I think it's very important and it kind of frames the entire discussion that we're about to have. The court says that the data exporter and importer, and as a backstop, the supervisory authority are required, and I'm quoting, to suspend or prohibit a transfer of personal data to a third country if, in its view, in the light of all the circumstances of that transfer. So there is an emphasis here on the circumstances of any specific transfer. And I'm continuing to quote, the standard data protection clauses are not or cannot be complied with in that third country. So this is one sort of condition. Is this a situation where the data importer typically thinks that they can't comply with the standard clauses in a specific third country? And I'm continuing to quote, the protection of data transfer that is required by EU law cannot be ensured by other means. So the court here kind of opens a path to adduce additional protections, additional safeguards, as the court calls it, to protect data transferred under the standard clauses. So there are two tests here. One, can a data importer comply with the standard clauses under domestic law of whatever country, again, in this case, the United States? And B, can the parties provide additional safeguards to the data besides that contract, essentially, which the standard clauses provide? Quick recap of what happened since then. A few days after the court decision, the European Data Protection Board, so this is the body of regulators of all European member states, issued frequently asked questions about the decision. Importantly, they stated that there is no grace period. The decision will apply immediately, and this means particularly for privacy shield companies that they have to pivot fast to something else. I can say that the FAQ stated that the EDPB will in the future provide additional guidelines about what additional safeguards companies could provide to protect data besides the standard clauses, and we'll talk about it more in this session. That guidance has not yet been issued. However, last week in its scheduled plenary meeting, the European Data Protection Board announced that it's setting up a task force, a special task force to provide these guidelines to data exporters and importers. So there's yet to be seen how they will interpret these provisions. In addition to that, a few data protection authorities stated their position about the Schrems decision, and they kind of range across the board. For example, the Berlin Data Protection Authority thinks that data transfers to the US are prohibited, full stop. The Baden-Württemberg Data Protection Authority, another German Länder, they have a federal system, so they have, I think, 17 state data protection commissioners. And Baden-Württemberg actually provided guidance under the Schrems decision. And the European Commission came out in a joint declaration together with the United States Department of Commerce, saying they'll try to find a solution. So, Safe Harbor, Privacy Shield, and now let's call it Safe Harbor 3.0 is being discussed. And I should say that in a session this morning, a Brookings session that Cam Carey hosted, and had European Justice Commissioner Didier Reynders on. Commissioner Reynders said that the Commission will, in the next few weeks, launch a process to come out with a new set of standard clauses. Some of you know that the latest set dates back to 2010, and this predates GDPR. So they will come out with a new set of standard clauses, perhaps providing additional protections beyond what is currently there. And he actually committed to finalizing this process by the end of the year. So within the next couple of months, before Christmas, probably we should expect to see a new set of standard clauses from the European Commission. And now back to the lead and the big story. Yesterday, the Wall Street Journal broke the news. This is leaked, so it's not an official sort of announcement of the Ireland Data Protection Commissioner, but the Wall Street Journal reported that the Ireland Data Protection Commissioner is about to issue an order to Facebook to halt all data transfers to the US under the standard contractual clauses. So this is obviously, an earthquake. And of course, not every company is Facebook, but Facebook will probably have to deal with this in the next few weeks. We'll talk about it more, what this entails. If you think about the impact this will have on you yourself, I'd emphasize here that this concerns transfers to the United States, so you might be transferring to other countries also. Here we are focused on transfers to the US. And B, that Facebook is a platform, a technology platform. It's an electronic communication service provider. So one of the companies that are squarely within the remit of Section 702 of the FISA, which is basically provides the US government, the national security agencies access to private sector data. Perhaps your company isn't, and perhaps it's transferring data to countries that are not the United States, so the implications might not be so harsh. I think I go back to the language of the court. You have to look at a transfer in light of all the circumstances and basically conduct a case-by-case analysis. The EDPB said that, and that's what we will focus on in this session. How does one conduct this case-by-case analysis? Sagi?
Okay, yeah, so really answering the question, now what, right?
Exactly. So we know what the court said. What are you going to do about it right now? You know, it's one thing to hear gloom and doom sort of on the news, but at the end of the day, you are managing a business and you need to make it work. This was my second slide, but I already covered it, Sagi, so you're behind.
So, yeah, well, I wanted to build attention. So really, if we go back to this question of this type of assessment, what it is that is expected of companies to be able to do and actually able to answer the case-by-case analysis of the circumstances. It comes down to data. At the end of the day, all of these discussions about the transfers and what can happen to the information comes down to the ability to control and understand the processing of the data, and the questions that companies should be able to answer to be able to do an analysis like that are really these four that are on this that you see on the screen now. You need to understand, you need to know which of the different processors that I'm using first and foremost receives the data from the European Economic Area, personal data. You need to also understand what categories of personal data from the European Economic Area these organizations, these processors are receiving, and I'm talking about Article 9 of the GDPR for the more sensitive data elements, as well as understand the purposes or the type of activities the data is being used for categorically, because that can help in the analysis as well. And we would like to make the point about some of the challenges that we will discuss later about being able to collect this kind of information about your sharing of data across a large enterprise. And we'll talk about this challenge of understanding the enterprise view of who from within my company is sharing information with this processor, and what data are we providing this one organization from different parts of our business. Then comes the question of which of these processors is outside of the European Union or the European Economic Area, and last but not least, the big question about sub-processors, which I think is at the heart of the challenge here. We are now operating in an environment that takes into account the fact that needs to take into account the fact that processors have their own processors. This is how we make money sometimes, and a processor that might still be situated in the EU and the agreement between the exporter and the importer, or in this case, there is no exporting and importing. The agreement between these two organizations does not account for the fact that the data then leaves from the processor to other countries. And here is the deep challenge that organizations have, and this is where I'm really drawing on my consulting background after spending a lot of time working with companies from different countries on managing personal information. And I can't but stress here that really the biggest challenge organizations have when it comes to managing their personal data is this notion of disclosures, and especially when it comes to vendors. Disclosures outside of the organization can also happen with co-controllers, with partners. Those, I have to say, from my experience in the last 20 some years, those are a lot more focused. There is a lot more attention to these types of agreements, and they don't seem to be as evolving as a long-term relationship with the vendor. So here are some of the reasons why answering the question that coming up with the responses to the 4 questions I raised in the previous slide is a challenge, even today. With some large organizations, procurement may operate at different levels. You would have business units conducting agreements and sharing data without informing or without having to get an approval from a central source. This is usually the case when it comes to lower threshold contracts, which actually can end up adding up if you can have if a business unit would have multiple small agreements. Each of these smaller agreements, smaller threshold agreements, would fly under the radar, would not go through a central process, but overall, over time, would actually add up to a significant amount. Contracting is a challenge, and maintaining the contract, the actual agreement, the original agreement, is not as obvious as you'd expect it to be. I've seen many cases of missing contracts that are maintained in paper and eventually disappear, and even the adoption of contract management systems that really is supposed to digitize a contract and allow an organization to understand the details of an agreement without having to go and look for it in detail in a long document. Those are not always used as intended. I've seen organizations that just basically take an image, load an image of the contract into that system, so the benefit of it goes away. The statements of work that are being signed based on a master services agreement can deviate significantly from the restrictions that were put in the MSA. Companies sometimes feel that they are protecting themselves legally by including in every agreement all possible requirements of a vendor, just to cover any type of data. I've seen international companies that would put in a HIPAA clause as a business associate that would discuss cross-border transfer just in case, even if it's a domestic agreement, and all type of breach notification commitments. That might make a lawyer feel more comfortable and protected that they were able to put these defenses, and in some situations, vendor would just sign it, hoping to get the deal, but it doesn't necessarily really reflect an ability to meet these requirements. Finding vendors, understanding who these vendors are, is part of the challenge, of course. In consulting, we used to do a lot of engagements, actually a lot of fun long-term engagements where we would pull accounts payable records and try to make sense of the records to identify who are the active vendors across the enterprise. This is not a sustainable solution. It's expensive. It takes a long time. There's a lot of false negatives and false positives in this process. And of course, as I mentioned, the big hole here is what happens with the sub-processor. The processor actually takes it to another organization. Now, these challenges lead to a status quo that is described on the right side of the screen. The challenge of getting an enterprise view of what a particular processor, or in the case of our discussion, an exporter that we're working with, what is the scope of the work that we're doing with them? Where is our data around the world? And thinking, especially if you put it in the context of the GDPR, being able to answer the question of what personal data, if at all, goes to a particular vendor, what data subjects that fall under certain requirements go to a specific exporter. For example, do I have GDPR impacted data going to this company? Do I have CCPA data, etc.? And which identities actually go to a specific third party? This is a huge order for companies, and in fact, I'm not sure that I know of a company that knows which identities go to which vendor or partner. But think about the requirements we have, the individual rights that we have to comply with, the ability to tell our processors that a particular data subject have changed their information or ask for their information to be deleted. I mean, how do you do that without knowing which vendor received that individual's information? I mean, the reality today is that if you want to do that, if somebody, for example, asks for the data to be erased, your solution at this point is to basically let all your vendors know that this person should be deleted, and in fact, you're actually proliferating further the information of a person that wanted to disappear from your system. So it's a big gap. Omer.
Yeah, thanks a lot. So again, if I can reflect on a couple of the things you said, and I think it's really great that we have this Israeli accented tag team of, you know, I come from the legal side and you come from technology and management, because these are really two, you know, obviously relevant, but not always kind of pointing in the same line. In the same direction. And I think with decisions like this, the Schrems II decision, before rushing to policy decisions and legal conclusions, and as you said, lawyers kind of feel more comfortable, you know, covering all bases and writing, like throwing everything but the kitchen sink into the 500-page service agreement. It's really important to pause to check what the reality is on the ground. Show me the data and show me the identities. And of course, that's what you guys, guys and gals at Data Guys and gals, I guess, do. You highlight the importance of subprocessors, which I think is a good segue to this next slide. And you know, if the listeners think about the Schrems case specifically, think about Facebook. One would imagine that Facebook has the resources and, you know, the cloud, the ability to localize, and they could conceivably just say, enough of this rigmarole, we are now going to put our servers in Ireland or, you know, somewhere in Europe and make it go away. I think it's a little naive to think this, because while Facebook obviously can afford it, the data is, you know, shared with an entire ecosystem of thousands or maybe tens of thousands of vendors and service providers and IT and marketing and what have you. And a lot of them may be based in the United States or in other, you know, quote unquote, non-adequate countries around the world. And Sergey, you kind of alluded to the smaller contracts that add up. For a company like Facebook, they probably add up to like a mountain, an avalanche of data transfers and data sharing. So even if one had the financial ability to withstand a full-on localization mandate, I think just the architecture of data flows and of the internet makes it incredibly difficult. And that's why it's really key to follow the data. In this slide, you'd asked me to provide a little more insight into the standard clauses themselves. So, you know, it's kind of an open secret in our industry that standard clauses for the longest time were kind of a sign and forget exercise. Companies would execute thousands of them and stash them in a drawer, and that was the end of it. I personally, you know, I've been in this field for 20 years. I don't know of a single case where these standard clauses were litigated by one of the parties or by a consumer. I may be wrong, but you know, there aren't many cases. I think suffice it to say that. Now, the Court of Justice is actually making us look into the contract and see what they actually say and try to operationalize it. And when you do that, you realize that it's quite a complex exercise. So you need to have an appendix for each processing operation, and you change it to keep it up to date. And you need to inform data exporters of any sub-processors and obtain their consent. That's required by Article 28 of the GDPR. And it's typically this list, which again is constantly changing, is added as an exhibit, typically Exhibit 2, because the standard clauses themselves are Exhibit 1 to the data processing agreement. You need to send a copy of sub-processor agreements to the data exporter to make them available to data subjects upon request. And important language that you find in there's a change in this legislation. So think about US legislation, for example, which is likely to have substantial adverse effects on these obligations. It will promptly notify the change to the data exporter as soon as it is aware, in which case the exporter is entitled to suspend the transfer. So, you know, if you think of trying to kind of thread the needle of the Court of Justice decision in Schrems II and to make it work for your company, one approach might be to hang your hat on this provision and say, look, we are not a tech platform. We are not a telco. We are not directly subject to FISA Section 702, which provides, you know, the NSA access to private sector data. To be sure, as interpreted broadly, we could be considered an electronic communication service provider under FISA 702 because we provide, you know, an email system for employees. That's enough under the Department of Justice interpretation. But you know, for the past 20 years, we've never received a national security letter, and the US government has never asked us for data. If and when we will be approached by the US government and feel compelled to provide access to data, then we will give you the exporter the notice under this provision, and we will say, sorry, we can't comply with the agreement anymore. And of course, when you're served a national security letter, typically it comes with a gag order, and you're not allowed to tell. But here you wouldn't be telling. You're not saying the reason. You're not saying you received, you know, a legal process from the U.S. government. You're basically saying I can't comply with this contract anymore. And perhaps this is a way to make it work. Back to you, Sagi.
Yeah, I have to ask you though, Omer. I mean, and I realize I'm kind of jumping to an internal Q&A for us, is because you mentioned that this morning there was some statement made about updated contractual clauses coming out soon to align with GDPR. When I'm thinking about the aspect of the sub-processors as they are covered in the current versions, I mean, I'm hard pressed to think of what else you can ask for in an agreement to cover this question better. I don't know if you have any ideas of what can be changed that would actually impact what it is that we are discussing today, and especially in that context.
Yeah, look, my kind of cynical response would be that solving the legal problem that the European Commission is facing is above my pay grade, and certainly they're not paying me for it. And they do have, hundreds of lawyers at their disposal to figure it out. So I can trust they will word it accordingly. I think, the broader challenge is how possibly could a contract between two private sector parties ensure protection from overreach or just reach, depending on your point of view, by a government, and much less, the government of the United States. And I think the simple answer is that a contract cannot provide absolute protection, because at the end of the day, the US government will get its way, but you can do the utmost to protect the data. And one way is to, alert a party that you've been served a government request. Another way is to just offer transparency. And I have to say the tech platforms are already providing pretty comprehensive transparency report. It cuts both ways, because we can see now that Facebook, for example, is actually served tens of thousands of requests by the US government every year, and by other governments, I should say, around the world, for access to their user information. You can encrypt data, which would provide protection from the government. And we know, of course, Apple versus FBI, that a couple of Microsoft also, a couple of the big tech companies sought to preempt or prevent the ability of government to access their data, including by encrypting data and refusing to cooperate with the government in handing over the encryption keys. So again, it's a matter of risk mitigation. And I think this is a good place to talk about the supplementary measures that the court suggests and doesn't really elaborate. And maybe you can elaborate for us, Sagi.
Yeah, thank you. So let's talk about this notion of supplementary measures that we can add to our processing. And I think the correct term here, Omer, is we're not trying to. I don't think that anybody thinks that this can eliminate the risk from inappropriate access by a government entity, but I think the expectation is to make it as difficult as possible, so that we are minimizing it to the extent possible. And I would like to go over some examples that we at Data Guys kind of thought about in terms of what can be a supplementary measure that an organization can take that actually shows that you have minimized the chances for that exposure. This is just examples. And I would say one of the reasons why we thought it makes sense to kind of think aloud about those supplementary measures in advance is that I don't know that we can expect the EDPB to come with anything concrete. I mean, tell me if I'm wrong here, Omer, but I mean, the EDPB, I mean, the idea that the EDPB is going to give us guidance on supplementary measures that would actually be concrete examples of how to use technology for that's probably far-fetched, right? I mean, they're not going to come and suggest this technology or that, or talk about techniques and technical controls and etc.
Yeah, I think, never say never. The data anonymization guidance of the Article 29 Working Party was pretty specific and scientific. But yes, I agree that I think the expectation is that we'll see more principle-based recommendations as opposed to practical steps.
Yeah. So here's ideas of some of things that could be practical, and actually all of the things that we are listing here are things that can be done. I mean, technology, these are not unique technologies that we're talking about. Actually, none of it is groundbreaking. First, the first approach is to replace identifiers with unique IDs that, of course, the keys to them never leave the EEA. So basically bring it down to just the transactional data that the exporter needs to be able to provide the service to you. And instead of the full contact information and everything else that identifies a person, just use unique IDs instead. A similar yet different approach is the second one, and this uses a technology called format preserving masking. Format preserving masking takes the sensitive information, that the identifiable information, I should say. Some of it can be the contact information, other can be anything else that can help identify the identity, and replaces it with data that looks real but is actually fictitious. It does so. Format preserving masking actually does that consistently. So every time we change the name Omer Tene across the data set, it will always go to this fake identity that the technology replaces him with, and the emails and the phone numbers, etc. The advantage of that over the unique ID is that your processor can actually do a lot more analysis even with that fake data, because fake data can actually be created with the right parameters for the analysis. Zip codes can be maintained, or certain regions can be maintained, age groups, etc. Plus, it doesn't look like obfuscated data. It actually looks real, so somebody coming from the outside might not even realize it's not real. A third option, where possible, is to use a technology that allows users to sit in a country like the US. The third idea here is to have the data projected remotely to what we call a thin client, a device that doesn't allow any activity on the data, other just to any ability to maintain and copy it, and do the operations from the US without having the ability to maintain it in the US. The fourth idea is about minimization, and bring it down to real personal data, but not one that is in any way sensitive, or even maintain only data that is contact information, publicly available contact information to use. Another one is to do never maintain the data more than just a few seconds. Do the processing, conduct the activity, send it back, or immediately delete it. Never keep anything. Last is the diffusion of the data in multiple exporters. So even if somebody is after the data that your company has, they would have to go to multiple different exporters to get a full picture, because you are dividing it across different exporters. So making it hard as well. Omer, you had some additional ideas about safeguards more on the legal side.
Yeah, I have to say that your safeguards sound much more secure to me, and kind of restored my faith in global commerce, because it sounds like there is, there are actions one can take to mitigate risk, even under the strict requirements of the Court of Justice. There are some legal safeguards that you can also implement, and I think it's incumbent on anyone really transferring data from Europe, certainly to the US, but also to other non-adequate countries after Schrems II, to conduct transfer impact assessment. So if PIAs and DPIAs, privacy and data protection impact assessments were all the rage in 2019, 2020 brings with it, alongside COVID-19, also TIAs, transfer impact assessments. And here, you have to go back to the reasons that the Court of Justice invalidated the Privacy Shield, and to, sort of in broad brushstrokes, there are two main reasons. One is that the Court of Justice thinks that US government access to data is disproportionate under sort of fundamental right analysis in the EU. And second, the Court of Justice is concerned with judicial redress or lack of judicial redress in the United States for European individuals who might have been subject to surveillance. I think there's very little a company can do about the second factor, the lack of judicial redress. Obviously, it has to do with the United States legal system and with standing requirements, and it even goes back to the US Constitution because of the standing issues. But in terms of the proportionality of government access, I think there are distinctions that can be drawn. And I've actually mentioned this earlier in this session. The relevant section of US law, section 702 of the FISA, applies to electronic communication service providers, and not all companies are ECSPs to the same extent, I would say. Telecom companies, or if you're an AT&T or Verizon, you know, it's clearly the case that you're covered. If you're a tech platform like Facebook or Google, you're covered. But if you're you know, a retailer or a pharma or an ad tech company, maybe you're not covered, or at least not covered to the same extent. So I think a distinction can be drawn there. Again, a legal distinction when you conduct a transfer impact assessment. It won't give you 100% confidence, but it will give you some, you know, assurance in terms that at least you'll know you're not first in line to be enforced against. The other sort of body of law that was discussed in the Court of Justice decision is Executive Order 12333, and that concerns US government access to data outside the United States and to data in transit. What this means practically is government access to data that's shuttled on underwater, you know, cables under the Atlantic Oceans, on fiber optic networks. And I think the recommendation here for companies, of course, they can't, you know, protect their data against access under the Atlantic Ocean, but they can encrypt their data and just make it tougher for any adversary to read and understand. And in fact, that's probably a good idea to do it anyways, just as a good security measure. So this, you know, doesn't necessarily change the way one should conduct business. Don't volunteer data. You know, of course, you want to be a good citizen and comply with the law. And if the FBI knocks on your door, you're going to do what they tell you. But you shouldn't, you know, proactively provide government with access to consumer data. I think it's obvious for many reasons, and you should kind of work with the legal structure and requirements that there are, subpoenas, warrants, or whatever it is. And then transparency reports, I mentioned earlier, we've already seen them from the big technology platforms. They are most impacted, but it's a good idea to be transparent about access of government to your database or lack of access, and that can provide an exporter with some assurance. So I think these are some ways to try to provide legal, you know, assurances that data isn't just freely available to third parties and to the government specifically.
Omer, you mentioned before, Omer, that one of the regions in Germany, one of the local DPAs provided some additional guidance on supplementary measures. Are these kind of covered here, or are there any good ideas coming from Germany on that notion?
A good question, and I have to admit I didn't go back to reading the summary of their advice. The guidelines are in German, and there is, I think the IPP published a summary of it, but I think, you know, in general, this is the gist of it. They also talked about some of the technological solutions, maybe that you had mentioned, encryption, de-identification, and others. But yes, you know, I don't want to go into detail because I just don't remember the details.
Okay, well, thanks, Omer. We're getting now to the Q&A part of our session, and I'll ask my colleague Anthony Dezan to give us some of the questions that are coming from the audience. Anthony?
Yes, thank you, gentlemen, again for the presentation. This first question that comes in was touched up on the presentation, but I'll ask anyway for more elaboration. Question is, how does yesterday's news about the Irish DPA's preliminary order barring Facebook from transferring personal data to the US affect other companies' efforts to conduct transfer analysis following Schrems II?
So Omer, this is certainly for you, but
Yeah.
the gist in my mind is, and we've seen it before with Facebook. I mean, can the market learn anything from what's happening to Facebook? Or it's almost like there is a whole class of like 5 or 6 global technology companies that seem so unique that it's hard to know if anybody can draw conclusions from what's happening to them with regulators.
Yeah, and Sergey, I think it's a good point because, and you know, this is for us lawyers. As lawyers, when there's a decision that comes out, we draw distinctions, we draw analogies, or we say, you know, this looks the same, so watch out. For very few companies, it looks the same because, as you say, Facebook is Facebook. It's unique. There aren't many companies with its breadth and depth of data collection and sort of data based operations. But having said that, there are some. So those companies, you know, are obviously watching very closely. And you know, I have to say that the stakes are incredibly high. They couldn't be higher in our space, at least, because if you think about it, you know, Europeans conduct their day-to-day business and activities and life and relationships, not just with the companies, but also with the government and with each other through these technology platforms. It's not just Facebook. It's Google and it's Microsoft and it's Zoom and it's WhatsApp and you know. But most of all of these technology platforms, these communications platforms, are, for better or worse, based in the United States. It's just a fact of life. So for these companies, it's, you know, it's a difficult path and perhaps a painful path. And I think first and foremost, it will be a very legal litigation-based path, because whatever the order is that the Irish DPC will come out with, and you know, yesterday was just a leak of a preliminary order. So at some point, they'll come out with the final order. And if they order Facebook to halt data transfers, it will go, no doubt, to the cooperation and consistency mechanism at the European Data Protection Board. And if the latest Twitter case is any example, and that was a much more straightforward case of a data breach, here, of course, much, you know, richer and more nuanced issues come up. That means that we will see objections by some of the European regulators, and the EDPB will have to decide. And after it decides, we will see legal appeals, and either Facebook or the Irish Data Protection Commissioner or both will appeal the decision, whatever it is, to different courts, the Irish High Court and or the European Court of Justice again. So this is something that, you know, we will see play out over the next few years. And this is just in the Facebook example. Now, you know, expanded to some of the other platforms that I've mentioned. And so, you know, I think the short answer is that if you're not one of those platforms, you're probably not the primary target right now, which again isn't to say that when you present risk to the board of directors or to your senior leadership team, you can, you know, sort of write this off. You can't write it off because there is some residual risk here. But as a matter of prioritization and triage, I think you can say, look, we will do the best we can, but for now, the standard clauses are valid. We will try to provide additional protections, and we will arm ourselves with an opinion of lawyers who are saying why we are not like Facebook in this context.
Thank you. The next question that comes in is, I've heard some suggest that the HR data is less likely to be subject to government surveillance action in cross-border transfers. Why would that be?
Yeah, again, you know, this is a legal question, and of course, you know, I'm not privy to any classified information of the US or any other government, so I don't know what they're interested in primarily, but I think it's kind of common sense that the government is interested in communications data, and the Snowden leaks, you know, what started this whole process focused on the PRISM program and the upstream program, and all those programs concern access to information about consumer communications. I think it's not by accident that we hadn't seen the revelations address government access to HR data. So I would think, again, without knowing anything from within the national security apparatus, that this is data of lesser concern.
I would add here, Omer, I would slightly counter it by saying that one of the advantages of HR data for anybody seeking it is that it's generally of higher quality from a data completeness and accuracy perspective, because of the tax reporting that is being done of it, the various other labor-related reporting. That's a good data set to have to know what's current and what's up to date. So I don't know.
Yeah, look, I'm sure the government has interest in specific cases in seeking HR records and does that. But I think in those cases, it's more specific and targeted, and in fact might pass the test of the European Court of Justice for proportionality, whereas what the Europeans were primarily concerned about was bulk surveillance. And, you know, if I had to take a guess, again, without knowing it, I doubt that the US government is surveying HR data in bulk fashion.
Okay. All right. Our next question asks, does pseudonymization in the EU affect internal processing outside of the EU, as well as agreements with the sub-processor?
Maybe that's you, Sagi.
Yeah, I think that the important thing to remember about pseudonymization, and that is we're talking about changing the elements, kind of some of the examples that were given earlier for supplementary measures, so that the data can no longer be obviously identifying a person or otherwise making it less clear, is not does not render the data not personal. And that's an important distinction. We're not talking about changing the data and de-identifying it in such a way that it no longer can identify a person. We're talking about making it a lot more difficult to make sense of the data. So no, the rules still apply. What we're doing here is we're actually applying a measure that shows intent to minimize the exposure, eliminate data that is not needed completely, and then whatever is needed, making it more difficult to make sense of it.
And as a follow-up to that question, same person asked, what about sub-processors that require some PII to perform their services, for example, mass email systems?
Yeah, so that's a good point. I mean, the supplementary measures are not are not necessary. At least the supplementary measures that we presented in this webinar may not necessarily apply to every scenario. There could be scenarios where it just doesn't compute. You have to have this information, and in these cases, you have to start thinking a little bit more broadly about what vendors I'm using if I want to be able to pass a certain test, rather than trying to make very minor changes because of the processor's need for the details.
Okay. Next question is there any way for companies to eliminate risk of non-compliance with transfer rules?
Well, I think that's what we've talked about for the past hour. So I think the answer is yes. There are ways to reduce risk, and some of them are technological, others are legal or administrative. I don't think there's a way to completely eliminate risk, given, as I said, just the structure of the internet and of the cloud and sort of global data flows. It's very difficult to not transfer data, full stop.
Yeah, but and most important, I think, in the context of our discussion with the Schrems decision, we're talking about the challenge of a very sophisticated government from a technology perspective, and the US is not the only government that has strong capabilities. We keep speaking of it as if the government doesn't have the tools to go and get the data that they want, or that they don't even have it already. So let's keep it in proportion. It's almost like we are. I mean, there's a lot of what ifs here and some theoretical discussions about technical capabilities many of us don't even fathom for those governments to use to get what they want. Yeah.
Thank you. And then with that, we actually are on top of the hour. So if we were not able to get to your questions, we will do our best to get to them. I also want to remind everybody that within the next few days, we will be sending all registrants the recording to today's session, as well as the slides that were presented today. Again, I want to thank everyone for joining today, and have a good afternoon.
Thank you. Thank you, Omer.